Good afternoon, Commissioners. My name is Samuel Meller. I am an attorney and Assistant Secretary of Manhattan Community Board 5, and I speak in opposition to the Adorama special permit application. Chair Weisbrod, you said on Monday that you believe that we are a society of laws and that we operate under legal constraints, and therefore I ask the Commission to apply the law as it is written. The law for special permits and bulk modification says that the Commission shall apply mandatory inclusionary housing to a permit that allows a significant increase in residential floor area. It does not say that the increase in residential floor area is an increase in permitted residential floor area, and this word, permitted, is the key. Nowhere, not in the law, not in the CPC report, and nowhere in the legislative history of this text is the word permitted to be found. As a society of laws, we must apply the law as it is written, not as the department believes it to be. I invite the Commission to search the text as we have, or the legislative history as we have, to find the word permitted, and you won't. You will not find one reference to this interpretation. The department's interpretation is only possible if the text was different. As it was written in an email between John Mangin and Frederica Siegel on November 4th, 2015, the text would read, where a special permit application would allow a significant increase in permitted residential floor area. Mr. Mangin had to write the word permitted into the text of the law because without that word, without the additional word permitted, the department's interpretation is baseless. We're a society of laws, ladies and gentlemen of the Commission, and the department and the Commission must apply the law as it was written and enacted. Finally, I'd like to address the department's concern that the interpretation of ZR 7432, supported by Community Board 5 and the Manhattan Borough President, is an exaction. An exaction is a kind of eminent domain, Fifth Amendment taking of property, where the government demands a dedication of property to public use by a private landowner in exchange for development. First, the New York Court of Appeals has never declared an exaction unless there's a physical occupation of private property. Modest conditions on development, like affordable housing, are not exactions. Furthermore, according to the U.S. Supreme Court, exactions only apply when a municipality makes an individualized determination to a particular property. If the Commission fails to apply the non-discretionary mandate of MIH to this application according to the law, it would be providing evidence to a constitutional challenge to MIH. It would mean that in practice, MIH is an individualized determination rather than a non-discretionary mandate.